Welcome to Miranda Warnings Roundtable, discussing legal issues and current events. I'm joined on the roundtable by Liz Benjamin and Professor Vin Bonventre. Liz is the managing director at Marathon Strategies, a public relations and communications firm, and former host of Capital Tonight, a political and policy show focusing on New York State politics. And Professor Vin Bonventre, distinguished professor of law at Albany Law School and publisher of the New York Court Watcher, devoted to commenting on the U.S. Supreme Court and the New York State Court of Appeals. This week on Miranda Warnings Roundtable, we're very happy to have Liz Benjamin and Professor Vin Bonventre back with us to talk about the United States Supreme Court. Welcome, both of you.
Great to be here.
So,
red hot Supreme Court summer.
It's Supreme Court summer. We've had I'm going to say a very busy and dramatic Supreme Court session. And the question I have, we're going to talk about some of the
I don't know if it's been busy. They hardly decided any cases.
Oh my God, you don't think anybody works as hard as you do.
A lot of important cases. I mean, we're going to go over the numbers, the caseload numbers. The question I have, if you'd let me finish, would be,
why?
Is there such a thing as stare decisis anymore on the Supreme Court?
Look, stare decisis is one of these things that when there's a precedent we don't like, the heck with stare decisis. When there are precedents we like, all of a sudden we love stare decisis. It really depends upon whose ox is being
So
bored.
your feeling is that this is no different than any other term, that there's just as much respect for precedent as we've had in the court's history?
I think when we've had strong courts, and I don't mean courts that we necessarily like, but strong personalities on the court who wanted to be active, there hasn't been much respect for stare decisis. Certainly, for example, during the late 50s and during the 60s, when Earl Warren was Chief Justice of the United States Supreme Court, a slew of precedents were overturned. And, we liberals just love that.
How many in a slew? Is that more than a flock of...
Well, if you think about just about every right that we cherish, right? Those rights were recognized by the United States Supreme Court in the late 50s and throughout the 60s, and they did so by overruling precedents who had denied those rights. So now that there's a conservative court, we liberals don't like it so much, and we're insisting on precedent. I'm not insisting on
Liz,
precedent.
any thoughts on the Supreme Court, just big picture?
Yeah, I tend to, again, I'm always sort of like the person who comes to it from a lay individual's perspective, right? Not a legal perspective. So I think most people look at the court and don't even know what stare decisis is or precedent is for that matter. So I'm not sure necessarily that it's something that concerns the general public. And I also agree that, people wouldn't be raising a hue and cry about it if they were so terribly concerned about the outcomes. If they were outcomes that we liked, then we would be fine. And they're not outcomes that the general liberal or progressive person has, is in line with.
Well, let's talk about some of the cases then. We've got cases, 40 years of precedent. For example, we'll talk about the Chevron overturning.
Sure.
But let's start with what I think was probably one of the most significant cases, which was the immunity case, Trump versus United States, where the Supreme Court now has like a 3-part test for whether a president's conduct is immune. And is there any constitutional precedent for this?
Sure. There's constitutional precedent. Nixon versus Fitzgerald, which said that Nixon could not be litigated against. That was in a civil case. Civil case. But if you look at the reasoning in that case by Chief Justice Berger, it by and large applies to presidential immunity generally for for actions taken in the exercise of presidential powers, right? And look, I know the liberals are gnashing their teeth, and this is the worst
let's not
thing.
call names here.
Right?
Right? So
Well,
we're just
the
looking.
liberals.
We're just looking at the
like
decision.
it because Trump won again, right? Look, I'm a liberal. I'm a liberal. And I didn't particularly like it, but I didn't particularly like Nixon versus Fitzgerald.
But looking at it from a legal perspective, not from a liberal versus
Right.
conservative perspective, is there anything in the Constitution that says the president is immune from criminal?
That's a great question, and it just shows what hypocrites the textualists and the originalists are, because there's nothing in the Constitution that suggests that the president should be immune from criminal prosecution. There is nothing in the Constitution that suggests that the president has immunity at all for absolutely anything. It's not mentioned in the Constitution. And yet the textualists and the originalists just line up, oh yeah, there's immunity.
And the same judges that last year in Dobbs said, well, there's no constitutional protection right to abortion, the same judges found a constitutional protection for presidential immunity.
That's right. Well, look, I told you last year, or a couple of years ago, David, that this nonsense about it's not in the Constitution is just that. It's just pure, absolute nonsense. Now, presidential immunity makes sense sometime, at least in part. Perhaps the Supreme Court this time went a little bit overboard. But I think Amy Coney Barrett, in her concurring opinion, well, it was concurring and also dissenting, I think she really hit the nail on the head, which is that if the president is prosecuted for non-official activities, right, according to the majority, the prosecution cannot even bring up the presidential action that was affected. So, for example, if the president is bribed for a pardon, right, you can bring up the bribery, but you can't bring up the fact that he pardoned somebody for the money that, he accepted in the bribe. So I think she hit the nail right on the head.
Liz, what do you think how do you think this looks to the citizenry?
I think that, the immunity question is not one that is going to have significant impact on the election. Generally speaking, I think the average person is like, so if you're saying that the president could murder someone and then subsequently be immune, that hits wrong. But a lot of this is, so you're saying that the president could be potentially held responsible for the actions of other individuals because that the president was seen as encouraging that action. I don't know necessarily that many people have a problem with that. It's the extreme action, which this president did not take. He did not personally murder anyone. But the suggestion that somehow, it's really, I think the average person understands if you commit something, an act in the context of your official responsibilities, then you should not be held responsible for that. For example, one might argue that a president who sends soldiers to war, who then subsequently die, could be held responsible for the death of those individuals by sending them to war, especially lately since we see a lot of conflicts engaged in without votes of Congress. So, obviously you can't have a president be held responsible for that sort of thing. That's where this gets a little sticky. And again, immunity, what does that mean? Again, if you don't watch a lot of Law and Order, and I don't necessarily that you know what that means or care, quite frankly.
Well, Liz, I think once you put your glasses on, you spoke with much more authority, honestly.
Oh, Lord. But Trump had a good year, right? He had a very, very good year. And I think
he had a good legal year with the exception of New York, which didn't go so great.
Yeah.
But, politically, which is obviously outside the realm of this conversation, I mean, he hasn't had the greatest week from a political standpoint, but on the legal front, yeah, he had a really good year. Let's, not forget Georgia, for example. Let's not forget Mar-a-Lago and the documents case. So there are a lot of decisions that went in his favor, and, I believe he's appealing in New York.
Yeah, and so let's talk about that a little bit, because in this decision, almost completely gratuitously was a concurrence by Justice Thomas that said, even though it didn't come up in this case, I don't think the special counsel is legal and constitutional. And then sure enough, a couple of weeks later, the use of the documents case in Florida was dismissed by the district court judge, who said, well, maybe the special counsel was not constitutional.
Yeah, well, Thomas is just parroting what Scalia said a long time ago about the special counsel rule. And I'm not saying that there's no merit to what they're saying, but among other things, what they're saying is that special counsel is obviously a higher executive official, and therefore, if he's a higher executive official, should be nominated by the president and confirmed by the Senate. And that's not the way we appoint special counsel. So they have a point. It's not like what they're saying is crazy, but again, precedent says otherwise.
But in this case, the case against Trump regarding the withholding of
you mean because of the
confidential security
trial judge?
Yes.
Yeah, but she's a little nutty, right? I mean, she's
this is not personal. I mean, it's just.
No, I don't mean to be personal. I'm talking about in terms of the law. She's pretty nutty, and in fact, the circuit courts, which have reversed her in the past, made it pretty clear they thought some of the things she was saying were crazy.
But in this case, it was the documents case was thrown out.
Yeah, well, we'll see what happens when it gets to the appeals court.
The other big case in the Supreme Court was the Loper versus Raimondo, which overturned the Chevron case, which provided deference to administrative agencies for over 40 years.
Yeah, 1984 case,
now,
yeah.
where you would give deference to the agency decision, and now there's no deference. Completely upturns the administrative front.
Now, this is another situation where I would argue, again, the average person, if you say Chevron to the average voter, they are probably thinking of, I don't even know what they're thinking of. But this case has the possibility of really making far-reaching and significant impact on average people's lives, where you have non-data-driven individuals making decisions that impact the public health and welfare of millions of people. That is a significant thing that I don't think has resonated the way that it should. And again, it's difficult to explain to people. I think when people start talking, like, for example, not to go too far afield, but the Democrats are talking about, like, election of, the former president is a threat to democracy. That's such a big thing for people to wrap their heads around. They are more interested in, like, a year ago, I paid X for eggs and now I pay Y. Right? Or a year ago, my electric bill looked like this and now it looks like that. So am I going to be better off under the former president if he's reelected, or the current Democratic regime? So, but the Chevron decision has some significant implications that I don't think we've even started to understand.
Yeah, and just to be clear, under Chevron, and you're right, everyone doesn't know what that means, but requires courts to defer to agencies' reasonable interpretations of statutes, and now courts don't have to provide that deference.
Right. I think the major impact that will be felt is that the court can now, by and large, disregard, for example, environmental protections of the EPA, worker protections of OSHA. And we can go on and on and on. That's what this is really about. Who are we kidding? You don't want to talk about liberal and conservative, but this is what we're talking about. These agencies, by and large, are filled with supposedly very expert, scientific, and data-driven experts. And, political conservatives aren't too crazy about that.
Some of whom left under the former administration, right? Like you did have some, I don't want to say mass exodus, but significant departures from critical agencies as a result of, certain politically driven or ideologically driven decisions. I mean, the whole purpose of having a cadre of government workers who are ostensibly not appointed, don't work at the pleasure of the executive, is to have institutional knowledge and individuals who make information based on science and based on data that has nothing to do with politics. This decision undercuts that.
That's right. And they don't have to worry, right? They're immune from politics. They don't have to worry about whether their decisions are popular or not. And again, what we're talking about is the environment. We're talking about workers' health. We're talking about food and drugs. That's what the kinds of things we're talking about. Now, the other side of the coin is, again, I think that the liberals are going overboard.
You're not allowed to say liberal. We're not saying that anymore, Ben. You need to.
No,
You
can,
I'm
but
allowed
it
to say,
honestly
but
kind
that's
of undercuts whatever point you're making because
but that's who's complaining
people see
about
red.
the overruling of the Chevron doctrine.
That's true.
That's not true. Chevron was and has been followed by administrations, Republican and Democrat, and I think it's been accepted as a method of moving forward. And so the question is, now, we heard from Chief Judge Roberts that judges are supposed to just call balls and strikes. Now takes it out of the administrative agency's hands, and now the courts will be deciding all of these things, all of these data-driven things. They're going to have to be experts in everything. And this seems a little bit contrary to what Chief Judge Roberts said when he said, well, we're just calling balls and strikes.
Well, look, there's a reason why the decision was 6-3. It was the typical lineup of the political conservatives versus the political liberals. There's a reason for that, because political liberals tend to like these administrative agencies which are independent and don't have to worry about politics. There's a reason for that. But I can tell you, as one who served as a law clerk and who had to deal with this deference to administrative agencies, sometimes it made you pull the hair out of your head because it was just an excuse for the courts not to actually get in the weeds and decide the case. They say, well, the administrative agency said this, that's the end of it.
As long as it was reasonable. If it was unreasonable, then they could step in.
But we're talking about statutory language. And if statutory language is ambiguous, it seems to me that Chief Justice Roberts is absolutely correct that that's a role for the courts to decide what the statutes mean. So I don't think he's wrong about that.
What do you think about the, I'm going to say, kind of a companion case, SEC versus JARC, where they said the administrative courts of the SEC, as well as other agencies, are unlawful?
I think the same thing. I think there's a great deal of merit to what.
So all of those cases are going to have to go now to the federal district courts, right? They can't be decided anywhere else. It's going to bog the courts down, don't you think?
Well, no? I think when we are talking about a penalty being imposed by an administrative agency for violation of something that looks, smells, and tastes like a common law crime, right? Well, that's something, it does seem to me that the Seventh Amendment is saying you're entitled to a jury, right? So, I think what Chief Justice Roberts is saying, again, has a great deal of merit. It's not necessarily the way I would have voted, but I think there's a great deal of merit to that. Remember, you have an administrative agency. They promulgate the regulations. Then they investigate violations. Then they prosecute the violations. And then they decide what the penalties are going to be. I mean, come on. one of the principles of adjudication is that we don't allow people to rule on a matter in which they have an interest. And in these cases, the administrative agencies have an interest because they promulgated their own regulation, they've prosecuted it, and now they're also the judge. So again, I think there's a great deal of merit requiring a jury trial if we're going to be imposing these quasi-criminal penalties for a quasi-criminal matter.
That's conceptually, that is a lovely concept. The problem that, as David points out, is that our court system is already so bogged down and backlogged that you're going to be waiting on decisions for so long. Like, I don't know how that's helpful to anyone.
Right, but I don't think the Seventh Amendment says, well, if it becomes difficult, you can ignore it. It doesn't say that. All these things are so difficult. We've had a few Fourth Amendment.
I get it. I'm just saying that it seems to me, even though this is not probably the appropriate terminology, but a little bit like an unfunded mandate. So to make a decision that further chokes the court, which is already overflowing with all sorts of things, and it takes forever to get anything ground through the extra fine wheels of justice, then you might want to address that with, streamlining the process or adding additional judges, which, was happened in New York, for example. So again, to expect that people, I understand that there's no legal expectation of an expedient decision, but I don't think that gumming up the works is, helpful to democracy.
And what we're seeing now, we've got 40 to 45 years of precedent of operational expertise and understanding that is just out the window. And now our federal agencies have no enforcement mechanism. So agencies will be doing what at this point? They're not going to be enforcing anything.
Well, they can be enforcing it, but not when we're talking about civil penalties that look, smell, and taste just like criminal penalties. And when we're talking about these civil violations that look, smell, and taste just like criminal laws. That's all Roberts is talking about. If we're not talking about, we're just talking about a pure civil violation. He's not talking about that. He's talking about, these things that, again, look, smell, and taste like criminal prosecutions. And there have been people complaining about these for a long, long time.
Right. So I want to talk about two gun-related cases. The first, U.S. versus Rahimi, which I think the last time we talked, we said this was one we should keep an eye on, where the issue was was it okay to prevent a proven domestic violence abuser from receiving a gun, and the court held that you could, that was in fact constitutional. But what's interesting is, in the Bruen case, which this arose out of, they said you've got to look at what the laws were back when the Second Amendment went into effect, and now, there was very different laws regarding domestic violence back in the 1700s.
But it was pretty plain that the rationale Thomas used in the Bruen case was ridiculous. I don't know where he came up with that. And the Rahimi case is another one of those cases where you have Chief Justice Roberts. And by the way, it was a great year for him. But Chief Justice Roberts.
Was it a great year?
It was a great year for him.
How was that?
I'm not following that either. How?
He won just about everything. He won just about everything. Whether you agree with him or not, he won just about everything. And it seems as though he's taking control of the court again.
Well, can I just ask a question about that? I don't want to go too far down this rabbit hole.
Go ahead, Liz. I welcome Liz's
do we think that some of that, if in fact we believe that premise, do we think that some of that has to do with the negative coverage received by some of the more conservative justices related to the outside influences that they may be subject to, or ethical questions related to gifts that they've received or flags that they've flown or their wives have flown or what have you, which to some degree weakens them and puts him in a more a strengthened position from the chief judge's standpoint.
It could. I mean, the Supreme Court looks pretty bad, and Roberts has an interest in making it institutionally look a heck of a lot better. But for example, in the Rahimi case, he did what he's done plenty of times, is to clean up an opinion that it's usually Thomas or Scalia has written in the past, clean it up and say, well, the votes really weren't there for this particular thing. So Bruin, it was pretty clear, Thomas said there had to be this law in the past, right, limiting the right to bear arms. And so in the Rahimi case, Roberts says, well, what we really meant was that there had to be something that was similar, right, to the law that we have now. He's done that quite a bit. Well, and, he got everybody on the court.
He did, 8-1. It was except for Thomas.
That's right.
Citing his own precedent.
Of course.
So, he did. But this is what I mentioned right at the beginning. There's no respect for precedent of even 2 years ago.
Yeah.
Right? I mean, everything's up in the air. Not saying whether the decision is good or bad. This one, I think, makes sense. I agree with that, but it's all up. It's not consistent with Bruin.
Right, but remember, it's been a historic principle at the court that stare decisis and precedent are not nearly as important when it comes to constitutional cases. All right, the Brandeis dichotomy. In most cases, you just want to rule. And if Congress or the agency doesn't correct your decision, fine, it stands, leave it alone. But when it comes to constitutional decisions, realistically speaking, the court is the only one that can correct its mistake, because the amendment process to the Constitution is extremely difficult. So the Brandeis dichotomy says that stare decisis and precedent are much, much less important when it comes to constitutional decisions. And that's what we're talking about here.
There was another, I think, significant gun case regarding bump stocks. The Garland versus Cargill,
right,
where they said bump stocks are not properly considered semi-automatic weapons.
Yeah.
Right?
What do you want? Ridiculous, right? And they gave that to Thomas, right? Thomas wrote that, and he said that bump stocks aren't the same thing as automatic weapons, as machine guns.
Whatever. No, I'm not. That begs credulity. I'm sorry.
I mean, what do you want? The other thing, the background of that also is that the ATF, so the Alcohol, Tobacco, Firearms, and Explosives Agency, flipped. It used to be that they would always say that bump stocks do not make a weapon, a machine gun, right? And all of a sudden they changed and they said, oh, yes, it does.
Well, because the technology increased, right?
Yes.
So when you added a bump stock now,
right,
it's no different than having a machine gun where you could fire off a couple hundred rounds like the person did in the Las Vegas shooting.
Right. But this is in one more case in which the United States Supreme Court is taking power away from administrative agencies. We're going to ignore you, the ATF. We don't like what you're doing. We think it's ridiculous what you're doing. We're not going to follow it. And of course, it's also a gun case.
Right.
In an election year.
Well, speaking of which, since the Supreme Court's term ended, we've more recently had a proposal by President Biden with respect to the Supreme Court that does a couple of things. Intends to limit the terms to 18 years. A judge would be replaced every 2 years, which means every president would have at least 2 times to replace a Supreme Court judge. So every 4 years you get 2 new judges. There would be a code of conduct that the president is suggesting. And also, as part of this proposal, talked about a constitutional amendment to address the presidential immunity decision. And I think all of those are worth mentioning. Now, let's talk about the Supreme Court terms. Does that require a constitutional amendment, or that would just be legislative?
If you have 5 votes at the United States Supreme Court that says that good behavior means for lifetime, yes. But the Constitution itself does not say that the Supreme Court justices get to stay on the bench for life. It absolutely does not say that. So good behavior can mean good behavior during the 18-year term. And by the way, that's a proposal that was seriously put forward quite a number of years ago, and it is quite popular among judicial scholars who think that it makes absolutely no sense for justices to be on the court for over 30 years, or for by accident you have unpopular presidents like Trump being able to appoint 3 justices, and you have other presidents, they're there for 8 years and they only get to appoint 2. So the proposal seems to make sense.
Let's remember, when we originally set this up, people didn't live until they were 90 on the regular. They lived until they were 60 and then they died. It wasn't, and we didn't have to get into this whole debate related to mental acuity and physical capability and all the rest of it. Now, we could have this conversation in New York as well, where the retirement age constitutional amendment was rejected, if I remember correctly. And there was an argument that was made in part that there was an equity and
Are you talking about for judges?
What?
Yeah. No, yeah. For judges, no, there is a mandatory retirement age.
Yes,
for judges
right.
in
And
New
the
York.
proposal was to expand it to an older age, to expand it.
Right.
And it died. It didn't work. And there was some of the argument was, if you do this, you will further quash diversity and equity opportunities for individuals who are coming up the food chain. Similarly, one might argue we don't have the diversest of Supreme Courts at the moment. There's some diversity, but not, there's a number of women, there's, a number of two individuals of color, I believe. But you are really, when you put people on for life and they live until they're 90, you really, not just from a political perspective, which is what you just mentioned, Vin, and certainly there's an argument to be made there, but you really quash the capabilities of, putting other voices onto one of the most powerful judicial bodies, the most powerful judicial body in the nation. And also you would think, and we haven't seen it, remember Ruth Bader Ginsburg was under enormous pressure as a result of her health to step aside, and she refused to. And, one might argue we're in a pickle as a result of it in some cases. But, we also saw just recently the current sitting president basically get bullied out of running because of questions related to his mental acuity and physical frailty. So it's possible that somebody at the Supreme Court level would get run out at a rail, but the pressure would have to be enormous. The life term just doesn't make sense in the modern era.
Well, Liz, let me ask you, so sounds like a reasonable proposal. Does it have any political legs? Is this going to get through Congress?
0.
Right? So...
Well, not now, as long as you have a divided legislature, right?
Once again, this doesn't seem to be a particularly liberal versus conservative position. They're saying it's not just conservatives would go out after 18 years. It would be a standard for whatever judge was on the bench.
In the long run, it's not a liberal or conservative thing. In the very short run, it's the liberals who are pushing this because they don't like what happened with Trump. They don't like what's going on at the United States Supreme Court right now, and they certainly would like to get rid of some of them who've been on the court for a long time. There's no
conservatives that think this is a good idea?
What? Oh, no, there are conservatives that think it's a good idea.
But the appointees that the former president made are quite young, actually, relatively speaking, right? So I think that the other question is, I mean, I don't think it's going anywhere. Would it be more politically palatable to do this as opposed to expand the number of bodies on the court, which has also been discussed? That is a slippery slope because, you go from 9 to 12 and then the next president comes in and is like, no, 12 to 18. And then where do you stop?
I'm also assuming that, if in order to make it not political, not particularly going after any particular judge, to say going forward that this would be the case, that we would let the current judges write out their appointments.
It would just ensure that whoever is the president, whether it's a Democrat or a liberal, if they're in the office for 4 years, they get 2 nominations, right? If they're in for 8 years, they get another 2. Right. But it's not one of these things you're in office, for 4 years and, all this hullabaloo.
You get 3,
and you get 3. Or Carter got none. Yeah.
Right. So let me ask you about the second part of this, the proposed constitutional amendment to limit presidential immunity that the court provided. Does that have any likelihood of success, or is it just...
Again, I think as long as...
That would have to be a constitutional amendment. That would have to go through Congress, and it would have to go through 3/4 of the states.
Yes.
Is that going to happen?
It would, except for the fact that depending upon who's on the court, they may say that the immunity decisions were really not constitutional decisions. Because you have to remember that it's a pure policy, right? There is nothing in the document that even suggests...
Well, no, but he's suggesting that the Constitution be amended to include this provision.
I know, but I don't think you would necessarily have to amend the Constitution to overrule a decision of the Supreme Court, which is not based on anything that is actually in the Constitution.
You absolutely would. Otherwise, the Supreme Court decision would stand.
Well, no.
You're saying we'll just get a new Supreme Court and then they'll change it?
The Supreme Court decision is not necessarily a constitutional one. The Supreme Court itself has inferred from presidential powers that it makes sense for the president to have immunity.
Well, maybe I'll ask the same question to Liz, and maybe she'll answer me.
I did answer you. I think depending upon...
You gave her other politic answer.
You're telling me it's not necessary.
It's not necessarily a constitutional requirement.
No, but he's proposing it as a constitutional amendment to the Constitution. Is that going to happen? That's my question.
Look, I think that, again, this whole, today, I believe, marks the start of the 100-day sprint to the end of to the general. The entire landscape has been upended twice now. We don't have the same Democratic nominee that we had before, and the former president, who's the GOP nominee, had an attempt on his life. Both of those things, really changed the course of this race. And then I imagine that the Democratic presumed nominee will select a running mate, and that will change things again. And reception of the former president's chosen running mate has not been so great, so that could change things again. But the outcome of the elections, which could also decide control of Congress, is really going to make the decision related to what you're discussing, right? I can't tell you. I wouldn't have told you 3 weeks ago that there would be an attempt on Donald Trump's life. I wouldn't have told you 3 weeks ago that Biden would be bullied out of the race. So
I would be suspicious if you did tell me that.
Well, right. You would be very right. You would look at my internet footprint and wonder where the hell I've been. But the point is, I don't think this is predictable right now. I don't see the political appetite for it. And again, also, when you ask the average voter about their top 10, issues that they care about, what the Supreme Court looks like, they should give a hoot. They really should, because it's very significant, but it's just not top of mind. And so if there was a prolonged political standoff over issues related to the Supreme Court and its makeup, I don't think that the electorate would be psyched about that.
Right. I think we should also be clear on the fact that the Supreme Court's going to get this issue again, and it's not going to be too long from now, because they sent it back for the courts to apply whatever guidance the Supreme Court majority thought they were giving to the lower courts. But whatever the lower courts do, that's going to be challenged and brought up to the United States Supreme Court. And Chief Justice Roberts is going to have to clarify and refine what he said, in that case. So there you go. So I think we're going to get some refinements to it. Anyway, yeah.
You know how I feel about ethics.
Well, it's an absolute disgrace that the United States Supreme Court, right, is not governed by some code of conduct. Like every single...
they do have a code of conduct. We've discussed it here.
Code of conduct. Yeah, okay. And not enforceable. Nobody's monitoring it. It's a joke.
We've talked about this before.
I know.
What more do you want to say that you didn't say before?
What is it that we could possibly say?
Well, I think
the law.
what we could say is that if, in fact, a code of conduct does get through the Congress, and I think it would, if the Democrats have control of both houses of Congress, and we have control of and the Democrats have control of the White House, it will go through. And then it's going to be up to the United States Supreme Court to say whether this is a violation of the separation of powers. And because of what Liz said, the reputation of the court is so low, right? Because of what some of these characters have done, some of these luxuries that they've accepted. It's a possibility that the Supreme Court, I think, would uphold it. We know that Kavanaugh, Amy Coney Barrett, and we know that the three liberals would love to have a code of conduct. So we may have 5 votes at the court to accept a code of conduct.
Liz, are we going to see a code of conduct come out of Congress?
I can't. I don't know. I don't know what Congress is going to look like. I don't know. Also, again, I can't see, it can't be a first 100 days kind of a thing. It is not a top priority for folks. They want to see what you're going to do about immigration. They want to see what you're going to do about inflation. They want to see what you're going to do about healthcare. Like, this is not, or maybe even the war in Ukraine, probably not. This is it's a very top of mind issue for what I would call insiders, but it is not a top of mind issue for regular folks.
Legal eggheads and political eggheads. It's what really concerns us, but probably not the public.
Probably not enough.
Good.
So thank you both for your insights about the Supreme Court. And I look forward to seeing you again very soon. This has been Miranda Warnings, a New York State Bar Association podcast. You have the right to subscribe, rate, and review.